Ready? Start. He summed up his arguments by stating that such a procedure was never contemplated under the Act. At this stage, it is important to note that the High Court allowed the criminal original petition and set aside the impugned GO issued by the government even before initiation of the proceedings under Section 4 of the Act. Para. Per contra, learned counsel for the respondents submitted that Section 3 of the Act is ambiguous as it does not indicate any procedure to be followed while passing an ad interim order. He further states that before taking any action under Section 3 of the Act, the competent authority has 9 to initiate proceedings and identify the properties in terms of Section 4 of the Act. Furthermore, he contends that the power of the government to pass ad interim attachment order is contingent upon identification of property by the competent authority. Para. In view of that, he submits that the High Court has rightly quashed the government order. Para. Having heard learned counsel for the parties and after perusing the impugned GO, it would be appropriate to bestow our attention to the relevant statutory provisions under the Act. A perusal of the statement of objects as well as the relevant provisions of the Tamil Nadu Act shows that its object was to ameliorate the situation of thousands of depositors from the clutches of financial establishments which deceives the 10 investors by offering high rates of interest on deposits and committed deliberate fraud in repayment of the principal and interest after maturity of such deposits. Subsection 3 of Section 2 defines the financial establishments. Para. It is an undisputed fact that the present respondents very much fall within the ambit of financial establishment as defined under the Act. Para. It would be appropriate to extract Section 3 and 4 of the Tamil Nadu Protection of Interests of Depositors within bracket in Financial Establishments bracket close Act 1997, which reads as under 3. Notwithstanding anything contained in any other law for the time being in force, whereupon complaints received from a number of depositors that any financial establishment defaults the return of deposits after maturity, or where the government have reason to believe that any financial establishment is acting in a calculated manner with an intention to defraud the depositors, and if the government are satisfied that such 11 financial establishments is not likely to return the deposits, the government may, in order to protect the interests of the depositors of such financial establishment, pass an ad interim order attaching the money or other property alleged to have been procured either in the name of the financial establishment or in the name of any other person from and out of the deposits collected by the financial establishment, or if it transpires that such money or other properties it is not available for attachment, are not sufficient for repayment of the deposits, such other property of the said financial establishment or the promoter, manager or member of the said financial establishment, as the government may think fit, and transfer the control over the said money or property to the competent authority. Full stop. Over.